I want you to picture something for me. Close your eyes if you have to, unless you're driving. You are in a city you know well. Maybe it's a Tuesday afternoon. The sun is out, the air is crisp. You've got nowhere to be in particular, you're just walking. Maybe you stop to look at a new building going up, or you check your watch to see if it's time for lunch. You are, by all accounts, just minding your own business.
Classic American pastime.
Right.
Just existing in a public space.
Right. You haven't stolen a wallet, you haven't punched anyone, you haven't even walked on the grass. But suddenly, a police car screeches up to the curb. An officer gets out, handcuffs you, and puts you in the back of the cruiser. You're panicked. You ask, "Officer, what did I do? What is the charge?" And he looks at you in the rearview mirror and says, "You were being annoying."
Annoying.
Or maybe you looked like a suspicious person.
It sounds like a nightmare.
Yeah.
It sounds like something out of a Kafka novel.
Yeah.
A bureaucratic labyrinth where you're guilty, but you can't quite figure out what you're guilty of.
It does. But the terrifying part, the part that keeps legal scholars up at night, is the question: how could you have stopped it? If the crime is being annoying, that depends entirely on the mood of the person looking at you. If the crime is looking suspicious, that determination happens entirely inside the officer's head. To obey that law, to be a good citizen, you would literally have to be a mind reader.
And since you aren't a mind reader, you can't obey it. And if you can't obey it, the government can theoretically lock you up whenever it chooses.
That is the tension we are digging into today. We are exploring that thin, blurry line between a safe society and a police state.
We are. And we're doing it by looking at one of the most fascinating, slippery, and absolutely essential protections in constitutional law. It is the shield against that Kafkaesque nightmare.
Welcome to Talk Trials.
I'm the legal analyst.
And I'm the curious guide here to ask the questions we're all thinking. Today, we are doing a deep dive into a foundational legal concept known as the void for vagueness doctrine. Now, I have to be honest, when I first saw the topic void for vagueness, it sounded like a stamp you put on a bad check. Void. It sounds so bureaucratic. But reading through this is huge. This is like the operating system of freedom.
It really is. It sounds technical, but it's actually very primal. It stems from the due process clauses of the Fifth and 14th Amendments. It's a constitutional rule that enforces a very old, very distinct maxim, nolla crimen sine liceo.
Which means?
No crime without law.
Okay, no crime without law. That seems simple enough. If it's not written down, you can't arrest me for it. That feels like day one of law school.
Sure. But the void for vagueness doctrine takes that simple idea and it weaponizes it. It says it is not enough for the legislature to just write something down. They have to write it clearly. If the legislature writes a law that is a word salad, or a law that is so mushy and broad that it could mean everything and nothing at the same time, the court steps in and says, this is void. It doesn't count.
It's like a teacher failing a student's essay because it's just gibberish.
Exactly. But in this case, the student is Congress or a state legislature, and the essay is the law that sends you to prison.
So today we are going on a journey through the history of legal gibberish. We are going to trace this doctrine from its roots in English common law all the way to the 1970s, where we deal with some truly archaic statutes about rogues and vagabonds, and finally up to the modern era where this doctrine is blowing up federal sentencing guidelines.
And, as is our tradition here, we will end with the 10th chair segment, where we offer our assessment of where this doctrine stands today.
Let's unpack this. Part 1, the roots. Where does this idea actually start? Because I assume politicians have been writing bad laws for as long as there have been politicians.
Chuckles. Longer, probably. To really understand the root of this, we have to go back, way back to 1610. We need to talk about Dr. Bonham's case.
1610. So we are talking King James I era, Shakespeare's still alive.
Right. And the legal heavyweight of the time is Sir Edward Coke. He's the Chief Justice of the Common Pleas. Now, strictly speaking, Coke wasn't dealing with vagueness in the modern American sense, but he laid down a dictum that is the spiritual ancestor of this doctrine. He argued that the common law will control acts of parliament that are impossible to be performed.
Impossible to be performed. I want to stop on that phrasing because usually when I think of vague laws, I think of confusion. I don't understand what this means, but Coke frames it as impossibility.
It is a brilliant reframe. Think about it. If a law is so vague that its meaning is unknowable, then compliance is impossible. You are requiring the citizen to know the unknowable.
If the law says don't be annoying, and I don't know what annoys you specifically, it is literally impossible for me to guarantee I won't break that law.
Precisely. You cannot perform the duty of obedience because the terms of that duty are hidden from you.
So flash forward. The Founding Fathers come over to America. They love Coke. They bake these ideas into the American system. But initially, early American courts didn't rush to strike down laws as unconstitutional just because they were vague. They used a softer tool, right?
They did. For a long time, they used something called the rule of lenity.
The rule of lenity. That sounds like a tiebreaker.
That's exactly what it is. It's a rule of statutory construction. Yeah. It basically says if a penal statute is ambiguous, if it could mean A or it could mean B, the benefit of the doubt goes to the defendant, the tie goes to the accused.
So you don't throw out the law, you let the guy go this one time.
Right. You narrow the interpretation to save the defendant. You sort of assume the legislature didn't mean to be cruel or confusing. But around the turn of the 20th century, we see a shift. We move from just interpreting laws narrowly to actually using the due process clause to strike them down entirely. And interestingly, this didn't start with street crimes or, the poor. It started with economic regulations.
Big business fighting back.
Big business fighting back against antitrust laws. There was a case, International Harvester Company v. Kentucky. Kentucky had a law prohibiting price fixing, but the standard was that you couldn't sell goods above their real value.
Real value. I'm no economist, but isn't value kind of subjective? Market value changes every single day.
That was the whole problem. International Harvester sells farm equipment. They asked, how are we supposed to know the real value of a reaper or a tractor in the abstract? If I sell it for $100 today and a jury 2 years from now decides the real value was actually $90, do I go to jail?
That goes right back to Coke. It is impossible to perform. I can't know what a jury in the future will think my tractor is worth today.
Exactly. The Supreme Court looked at this and said, this isn't just unfair. It violates the fundamental principles of justice. The court said this standard was unknowable.
So this is where the doctrine gets its teeth. It's not just about being nice to the defendant. It's about the legislature fundamentally failing to do its job.
Correct. And this all solidified in 1926 with a case called Connolly v. General Construction Co. This gave us the classic test we still cite all the time today. Justice Sutherland wrote that a statute is void if men of common intelligence must necessarily guess at its meaning and differ as to its application.
Men of common intelligence. I like that standard. It's not, can a team of lawyers figure this out? It's, can a regular person figure this out?
If you have to guess, the law is broken. And Connolly establishes that there are really two prongs to vagueness, two reasons a law can fail. The first is what we call fair notice.
Which is what we've been discussing, the warning label on the bottle.
Right. The requirement that ordinary people can understand what conduct is prohibited. But there is a nuance here that, we need to be honest about. It's a bit of a legal fiction.
How so?
Well, let's be honest. Do ordinary people sit around reading the penal code before they go out for a walk? I mean, do you?
I certainly don't. I don't think I've ever read the penal code of my own city, not once.
Most people don't.
Yeah.
So fair notice isn't really about whether you actually read the statute. It's often more about what we might call socialization notice, the idea that the law should align with general understandings of right and wrong. If the law says don't murder, you don't need to read the statute to know that's bad. You have socialization notice.
But if the law says don't sell a tractor for more than its real value, I have no social intuition for that at all.
Exactly. You need the text. And if the text is vague, you're lost. However, scholars and judges increasingly agree that the second problem is actually much more important.
Which is?
Arbitrary enforcement. The requirement that the legislature establish minimal guidelines for the police and for prosecutors.
This feels like the bigger issue to me. If a law is vague, it sounds like it just gives the police a blank check.
It does. Without guidelines, a law permits what the courts call a standardless sweep. It allows police, prosecutors, and juries to pursue their own personal predilections.
Personal predilections. That is a very polite Supreme Court way of saying bias, harassment, or just picking on people you don't like.
Exactly. If the law is don't be a bad person, the police officer gets to decide who the bad people are. And that is a legislative power, not an executive one. And historically, who gets targeted when the police have that power?
They pick the poor, they pick minorities, they pick the political agitators. Which brings us to what I think is the most colorful and honestly disturbing era of this doctrine, the vagrancy era.
This is where the doctrine really comes alive in a social context. We have to talk about Papachristou v. City of Jacksonville.
This case is from 1972, but the laws involved sound like they are from 1572.
They essentially were. These vagrancy laws were holdovers from the old Elizabethan poor laws in England. They were designed to control the movement of the poor, to keep labor in certain places, and to handle undesirables. By the 20th century, they had become a catch-all tool for police discretion.
Let's look at the ordinance in Jacksonville at the time. I have the list here. It's poetry. Really bad poetry. It criminalized rogues and vagabonds, dissolute persons, common night walkers, habitual loafers, and persons able to work but habitually living upon the earnings of their wives.
Don't forget, persons neglecting all lawful business.
It sounds like a character list from a Dickens novel, rogues and vagabonds. But this was the law in Florida in the 1970s, and the police used it to arrest the 8 defendants in this case. The facts here are just startling.
They are, and they perfectly illustrate the arbitrary enforcement problem. Take the first group of defendants, Papachristou and Calloway.
Right. These were 2 white women and 2 black men. They were riding in a car together on the main thoroughfare in Jacksonville. They were on their way to a nightclub.
And they were pulled over. The police arrested them for prowling by auto.
Prowling by auto? What does that even mean? How do you prowl in a car on a main street?
You don't. The officer later admitted he had no probable cause to believe they had committed a specific crime. But the racial mixture in the car and the context of the South in the 70s triggered the stop. The vague law gave the officer the cover to arrest them.
Then there was Jimmy Lee Smith. He was a part-time organizer for a black political group. He was waiting for a bus.
And he was arrested for being a vagabond and loitering.
And a man named Heath arrested for loitering while standing in a driveway, by the way, that he was standing in because the police told him to stand there.
So the police created the crime and then arrested him for it. This went to the Supreme Court. And Justice Douglas wrote one of the most famous opinions in this entire field. But Douglas was a bit of a romantic, a nature lover. He looked at this list: rogues, night walkers, loafers. And he realized that Jacksonville was criminalizing the amenities of life.
That's a beautiful phrase, amenities of life.
It really is. He quoted Walt Whitman's Song of the Open Road and the poet Vachel Lindsay. He made the point that walking, strolling, wandering, even loitering are historically part of how people enjoy life. They aren't crimes.
He pointed out that night walking might just be a person who has insomnia, and loafing. He actually quoted a governor of Puerto Rico who said loafing is a national virtue.
Douglas saw the trap. These laws cast a net so large it caught everyone. If you are wealthy and you stand on a corner, you are enjoying the fresh air. If you are poor and stand on a corner, you are loitering.
And the police decide which is which based on how you look.
Exactly. Douglas held that the ordinance was void for vagueness. It failed to give notice that innocent activities like driving to a club or waiting for a friend were criminal. But more importantly, it encouraged arbitrary arrests. It allowed the police to arrest people on suspicion of future criminality or just because they didn't like them rather than for past criminal acts.
It prevented that law by cop scenario. But this didn't end with vagrancy laws, did it? The cities didn't just give up. They didn't say, okay, I guess we'll let people hang out on corners now. They just tried to get smarter.
No, they didn't give up.
Yeah.
As vagrancy laws were struck down, cities tried to get more specific, but they kept running into the exact same problem. This brings us to the 1980s and the case of Colander v. Lawson.
This is the case about the man who liked to walk, Edward Lawson.
Edward Lawson was a black man with long dreadlocks who loved to take long walks, often in white neighborhoods in San Diego. He was detained or arrested approximately 15 times.
15 times for walking.
Well, technically, he was stopped under a California statute that required loiterers to provide credible and reliable identification when stopped by police. Lawson refused to identify himself.
So the crime wasn't the walking itself, it was the refusal to show ID.
Right. But here is the vagueness issue. What is credible and reliable identification?
I assume a driver's license.
Probably. But what if you don't have one? Is a library card credible? A piece of mail with your name on it? A verbal statement? The statute didn't say.
So we are right back to the impossibility problem.
Yes. The court struck it down. They said the statute vested virtually complete discretion in the hands of the officer to determine whether the ID was sufficient.
So if the officer likes you, your library card is fine. If he doesn't like the look of you, you're going to jail because your ID wasn't reliable enough for him.
Exactly. And the court made a crucial point here. It requires mind reading. How can a citizen know what a specific officer will deem reliable in that specific moment? It is impossible to know. Therefore, compliance is impossible.
This leads us to the 90s and City of Chicago v. Morales. This one feels much closer to modern debates about gang violence.
It does. Chicago passed the Gang Congregation Ordinance. It prohibited criminal street gang members from loitering with one another or with other persons in a public place.
That sounds slightly more specific than rogues and vagabonds, at least.
Slightly. But here was the trigger. The police had to order them to disperse. The crime was failing to disperse. And loitering was defined as to remain in any one place with no apparent purpose.
No apparent purpose. Oh boy, I can see where this is going. Apparent to whom?
Precisely. In 3 years, Chicago police made 42,000 arrests under this law.
42,000. That is an industrial scale of enforcement. That's the population of a small city.
The Supreme Court struck it down. They focused on no apparent purpose. That is inherently subjective. Does a person waiting for a bus have an apparent purpose? Probably. What if they were just talking to a friend? Is chatting a purpose?
If I'm just standing outside getting some fresh air, do I have a purpose?
The police officer decides. The court noted that loitering can be regulated if it's tied to specific harmful conduct like blocking a driveway or obstructing traffic. But you cannot criminalize loitering in the abstract. You cannot criminalize just being there.
It seems like there is a pattern here. The government tries to create a tool to sweep up bad guys before they commit a crime, and the court keeps saying, you can't do that unless you define exactly what they're doing wrong.
That is the core dynamic. But recently, the battlefield has shifted in a really interesting way. We aren't just talking about street crimes and police discretion anymore. We are talking about federal sentencing and judicial discretion.
This brings us to the modern era, and this is where the rubber really meets the road for us today. The case is Johnson v. United States from 2015. This isn't about loitering. This is about something called the Armed Career Criminal Act, or ACCA.
Right. This is a huge shift from the street cop to the judge in the courtroom. The ACCA imposed a mandatory 15-year prison sentence if a defendant had 3 prior violent felonies.
Wow. That's a huge enhancement. So the definition of violent felony matters a lot. We are talking about losing decades of your life over this definition.
It matters immensely. The act defined violent felony to include things you'd expect, like burglary, arson, extortion. But then it had this catch-all provision known as the residual clause. It included any conduct that presents a serious potential risk of physical injury to another.
Serious potential risk. I have to play devil's advocate here for a second. That sounds reasonable, doesn't it? I mean, driving drunk presents a risk. Carrying a shotgun presents a risk. Why is that vague?
It sounds reasonable until you try to apply it using the bizarre method the courts were forced to use. It was called the categorical approach.
Okay, let's unpack the categorical approach. This is where it gets technical, but I want to make sure I understand this.
So imagine you are the judge. I am the defendant. I have a conviction for attempted burglaries from 5 years ago. You have to decide if that was a violent felony under the residual clause.
Okay, so I pull the police report from my desk. I see if I had a gun, or if I punched the homeowner, or if I just ran away when a light came on.
Stop. You cannot do that.
I can't look at what I actually did.
No. Under the categorical approach, the Supreme Court said you can't look at the specific facts of the defendant's past crime. You have to look at the statute they were convicted under. And then you have to imagine the ordinary case of attempted burglary.
The ordinary case?
Yes, you have to imagine the abstract, platonic ideal of that crime. And then you have to ask yourself, does the ordinary way people commit this crime involve a serious potential risk of injury?
That sounds like a philosophy seminar, not a legal test. How does a judge know what the ordinary attempted burglary looks like? Is it a ninja sneaking in at night? Is it a guy throwing a brick through a window?
Exactly. How do you define the ordinary version of a crime? It's pure imagination. And judges across the country were coming up with wildly different answers for the same exact crime. One judge would say, ordinary burglary is violent. Another would say, no, usually it's just sneaking in when no one is home.
So you could get 15 extra years in prison or not, depending entirely on which judge you got and what they imagined that day.
Wildly different answers. In Johnson, the Supreme Court finally had enough. Justice Scalia, of all people, wrote the opinion. He called it hopeless indeterminacy.
Hopeless indeterminacy. That's a strong phrase.
He said that combining an abstract, ordinary case analysis with an uncertain risk standard created a situation where judges were just guessing. It wasn't applying law. It was rolling dice with people's lives.
And so they struck down the residual clause.
They did, and this was huge. It invalidated thousands of sentences across the country. And what's fascinating is that the government argued, hey, there are some crimes that clearly fit this, like attempted murder, that clearly has a risk. So the law isn't vague in all its application.
That seems like a logical argument. If it works sometimes, why throw out the whole thing?
The court rejected that. And this is the difference between a facial challenge and an as-applied challenge. Usually, courts prefer to just fix a specific case. But here, the court said the standard itself was rotten. Even if some crimes clearly fit, the measuring stick the judges were being forced to use was so broken that the whole clause had to go.
And this rippled out, right? It wasn't just Johnson.
Right. In 2018, in a case called Sessions v. DiMaia, they applied the exact same logic to immigration law. A statute allowed for the deportation of someone for a crime of violence. It used similar language to the ACCA. The court struck that down too.
And Justice Gorsuch weighed in there, didn't he?
He did. And this is important because Gorsuch is a conservative originalist. He wrote a concurrence reinforcing that this isn't some liberal, soft-on-crime idea. He cited the history of English common law and the need for fair notice. He basically said, if the government wants to deport someone, they better write a clear law.
So we have gone from annoying passersby on a street corner all the way to federal deportation statutes. And the thread connecting them is this fundamental idea that the government cannot force us to guess.
Or force judges to guess.
I want to take a step back and look at the theoretical mechanics of this. We've talked about the history and the cases, but theoretically, how does this actually work? You mentioned impossibility at the very beginning.
Yes. If we really look under the hood of the void for vagueness doctrine, it really boils down to two types of impossibility.
Okay. Type 1.
Requiring conformity to unknowable facts.
Like the International Harvester case with the tractors.
Exactly. The law prohibited charging unreasonable rates. But a reasonable rate is an economic abstraction. It doesn't exist in reality until a court decides what it is 2 years later.
So at the moment I set my price, it is impossible for me to know if I'm committing a crime.
Correct. The fact that determines your guilt, the reasonable rate, is unknowable at the time you act.
And type 2.
Requiring conformity to the subjective standards of others.
This is the ordinance about annoying people.
Exactly. That case was Coates v. Cincinnati. It was a crime to annoy passersby. But I cannot know what is going on inside your head. I can't possibly know what will annoy you specifically. Maybe you hate people wearing blue hats. If I walk by wearing a blue hat, I annoy you and I've committed a crime. But I can't know that. Compliance relies on me knowing the internal mental state of a complete stranger. That is impossible.
So vagueness isn't just, this is poorly written. It's, this requires me to be a psychic or a time traveler.
That is a great way to put it. And there's one more layer to the mechanics here. The distinction between conduct and correlation.
Explain that.
Okay, so there was a case called Robinson v. California. The state of California made it a crime to be addicted to the use of narcotics. Not to use them or sell them, but to be an addict.
So to have the status of being an addict?
Right. The court struck it down. You cannot criminalize status. You have to criminalize conduct. Vague laws often drift into punishing who a person is, a rogue, a gang member, a suspicious person, rather than what they did.
And correlation, what's that about?
This comes from Bowie v. City of Columbia. This was a civil rights sitting case. Protesters were arrested for trespassing. But the trespassing statute didn't actually prohibit their conduct at the time. So the South Carolina Supreme Court basically expanded the definition of trespassing after the fact to include them.
Retroactively, wow.
Yes. The U.S. Supreme Court said you can't do that. There has to be a correlation between the law as it existed when you acted and your punishment. The judiciary cannot create the crime after you've already done it.
So synthesizing all this, the Vagueness Doctrine prevents the creation of law after the fact, whether it's by a judge expanding a statute, a police officer deciding you look suspicious, or a legislature just refusing to be specific.
Precisely. It forces the state to define the crime before the citizen acts.
Which brings us to today. The doctrine seems pretty strong given Johnson and DiMaia, but it's not without its critics, right?
It is definitely under scrutiny, and the criticism is coming from a very interesting place, the originalist wing of the court, particularly Justice Thomas.
What is his objection?
He is skeptical of the historical pedigree of the doctrine. He argues that void for vagueness creates a situation where judges are acting like super legislatures, just striking down laws they don't like. He looks back at early American history and says, we didn't strike down laws for vagueness back then, we used the rule of lenity.
We just interpreted them narrowly in favor of the defendant.
Right. He worries that vagueness is too similar to something like substantive due process, the idea that courts can invent rights that aren't textually in the Constitution. He thinks if a law is vague, we should just read it as narrowly as possible to save the defendant, but we shouldn't necessarily wipe the entire statute off the books.
It's the difference between using a scalpel and a sledgehammer.
Exactly. Thomas wants the scalpel of lenity. The majority of the court currently supports the sledgehammer of vagueness.
But the stakes are high. One saves the specific defendant in front of you, the other invalidates the law for everyone.
Exactly. Striking it down forces the legislature to go back to the drawing board and do their job properly.
Which brings us to our final segment, the 10th chair.
Disclaimer. The following assessment is commentary for informational and discussion purposes only and does not constitute legal advice.
We've looked at the history, the cases, the theory. So, is the void for vagueness doctrine sound? Is it a necessary part of our legal system?
I would argue it is absolutely essential, and it all comes down to the separation of powers.
Break that down for us.
We often talk about fair notice to the criminal. But as we discussed earlier, criminals don't read statutes. The real value of this doctrine isn't just warning the bad guys. It is about constraining the government.
It prevents the legislature from passing the buck.
Exactly. If we didn't have this doctrine, the legislature could theoretically pass a law that just says, do not do bad things or do not act suspiciously. And then they could delegate the entire definition of bad or suspicious to the police officer on the street or the judge in the courtroom.
It effectively transfers the power to make law from the elected legislature to the unelected enforcer.
Yes. It creates a law-by-cop state. The police officer becomes the legislator, the judge, and the jury, all in one moment on the street corner.
And we saw in Papachristou and Morales exactly who gets targeted in that system. It's not the powerful, it's the poor, it's minorities, it's the unpopular.
Precisely. The doctrine forces the legislature to do the hard work of defining the crime. It ensures that the state defines the boundary of freedom before the citizen acts. Without it, the rule of law dissolves into the rule of police discretion.
So even though it can be messy, and even though it leads to some confusing court battles over things like sentence enhancements, it is a necessary backstop.
It is the barrier against that Kafkaesque nightmare we started with.
As we wrap up, I want to leave you with a thought. We are entering an era of artificial intelligence and algorithmic policing. We are seeing systems that flag suspicious behavior based on vast data sets.
Predictive policing.
Right. If a camera and an algorithm decide you are acting suspiciously based on a black box code that no human can explain, and you are detained because of it, is that void for vagueness?
That is the new frontier. If the law is an algorithm that is unintelligible to the human mind, have we just returned to the era of unknowable standards?
Can you obey a law that is written in binary code that you aren't allowed to see? A provocative question for the future. Thanks for listening to Talk Trials. We'll see you on the next deep dive.